Tenancy at will. People hear this term often, usually in the context of people buying or selling a home, but they don't understand it. Often it's kind of seen as a magic wand that fixes a problem, but it doesn't. There's some certain rules that go in that are required to be followed in order for someone to get tenancy at will. So what is tenancy at will? So this is a situation where someone is buying a home and they aren't able to close, whether it's the seller's fault or the buyer's fault. It's not material in that tenancy at will can occur in either situation, and it's going to depend on who is at fault, is if someone has a choice to grant tenancy at will or not. For instance, if a seller can't get the documents required to the buyer's lawyer, maybe they're out of country and the documents are just in transit still, maybe there's an estate and we're waiting for probate, or someone's a non-resident for tax purposes, and we just can't send that transfer of land. Now, because it's the seller's breach that they're unable to close on time, they're required under the usual contract that real estate agents use to give tenancy at will. Now, in a situation where a buyer is late, let's say their bank hasn't funded their mortgage on time, or they weren't able to attend at their lawyer's office, and so everything's kind of delayed, and now the seller has the option to give tenancy at will or not. Tenancy at will just means that even though you haven't paid, we're letting you take possession of the property, you're moving in, but it's a tenancy, like a tenant at will, meaning that the seller can kick you out if things don't close in a fairly short period of time. In order for a buyer to get tenancy at will, regardless of whose fault it is, they're going to need to have all of the documents signed, an unconditional mortgage that's been signed, a transfer back, transferring ownership of the property back to the sellers if they never get paid, a tenancy at will agreement, which will have provisions in it that says you can't destroy the house, not even do renovations, you can't rent it out, you've got to maintain it in good condition, you have to pay the taxes and utilities, and if you don't pay for the home in whatever the reasonable period of time is in the situation, they can kick you out with either 24 or 48 hours notice. You also have to prove, depending if it's a house or a condo, that you have insurance in place. So these are all things that are required for the tenancy at will. And last, you have to have your non-mortgage money in place. So if you're relying on bridge financing, funds from a sale of a property to buy a new one, and those aren't available, you can't get tenancy at will. If your bank is one of these banks that are virtual, where it takes a week in order to get a bank draft, and you don't have those non-mortgage funds, you can't get tenancy at will. Typically, that has to be in the lawyer's trust account to make sure that you're able to get it. And remember, you can't wreck the home. You can't start the renovations if you're planning to do that. If you have more questions, make sure you talk to your real estate lawyer. And often, your real estate agent and your real estate lawyer work together to determine if it's an appropriate situation for tenancy at will. Your lawyer should always give you the option as a seller, if you're not in breach, as to whether or not you want to give tenancy at will, collapse the deal, or any number of what your legal options are, but they should give you that choice. So make sure that they've done that so you can make a decision that's right for you.